What about life insurance, savings accounts, 401k, Roth? Do you name the trust as your primary beneficiary or your spouse? So we're going to take these up one at a time because often for different assets, there's a different recommendation. And I am going to say this, it can also change depending on your specific scenario. So whether or not you should list a trust as a primary beneficiary or transfer an asset into a trust, or whether you want to list an individual, these are things that you definitely need to discuss with a qualified estate planning attorney. And you probably also want to go over them with your financial advisor or CPA so you have a full, rounded idea of exactly what you should do. So that being said, I'm just going to give some general recommendations that we would give. So life insurance, depending on the amount, if it's under $1 million or under a couple $1 million, you can list your spouse as the primary beneficiary and the trust as the secondary or contingent beneficiary. For policies that are in the millions, it's not a bad idea to look into getting what's called an ILIT, which is an irrevocable life insurance trust, to handle that policy. Also, just depending on the purpose of the policy and what type of policy it is. So again, life insurance is a very broad category. It's going to have a different recommendation depending on the type of life insurance, what the intended use is for the death benefits, and also the amount, of the benefit. So it is going to be a different recommendation. But let's say you have a life insurance policy that pays out $250,000 upon your passing, something like that. Yes, you can name your spouse as the primary beneficiary. If you have a trust or revocable trust, you would name the trust as the contingent. Savings accounts, you can often just retitle into the name of the trust. So this is what we typically would recommend. You would have the account transferred into an account under the name of the trust. Now, if you don't want to do this, and there are sometimes reasons people don't want to do this, then yes, you could list the trust as the beneficiary of the savings account. It is often called the POD, or payable on death recipient, and not beneficiary to banking institutions. So keep that in mind. For 401k, we name the spouse as the primary beneficiary, and can name the trust as the secondary, especially if minor children or children with disabilities are involved. One of the benefits of adding the trust as a secondary on retirement, and typically we do say to name the spouse as the primary, on any type of retirement account, this would include the 401k and the Roth, is the trustee of the trust does have discretion over when to make distributions. Also, there was a recent case that came down where, although IRAs are typically protected from claims of creditors, that's not the case anymore, or it's not securely the case anymore with inherited IRAs. So another reason to have an IRA deposit into the trust rather than to an individual is you could have some extra legal protection there. But there are benefits if your spouse predeceases you as to why you might want the trustee to have control of those assets rather than going to individual beneficiaries. Now, that being said, I still have many clients that name their adult children as the secondary beneficiaries, and that's mainly when those children are looking to roll over those IRAs, retirement accounts, into their own type of an account. Maybe they already have a connection with that particular financial institution. So this is, again, an example of where you're going to want to go over the full scenario with both your attorney as well as possibly your financial advisor and a CPA, so you get tax advice on what's the best for your scenario, because these will make a difference depending on your specific situation. I think, yes, so I covered everything that was in this particular question. Now, of course, besides these assets, there's all sorts of other assets that you don't want to miss. Remember, the big thing here is once you have that trust agreement signed, you do have to take the second step, what we call funding the trust, and that's either transferring assets directly into the trust assigning them to the trust, or naming the trust potentially as a beneficiary. This is a very important process, the most important, because if you don't do it, your trust is basically worthless. So make sure you spend the time to really get to know the importance of this and what you should do, and really know the ins and outs. Your attorney should be able to help you with this. If not, you need to get another attorney. I can't stress how important this is. So I hope this answered the question, or at least gave you some kind of general idea about naming spouses in the trust as beneficiaries on these particular assets. If you have any other questions about revocable trust, funding trust, estate planning, asset protection, probate, Medicaid, and you're in Florida, please don't hesitate to reach out to our law office. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.